We wanted to start with just a quick introduction of what we hope to accomplish in this webinar. We anticipate significant discussion on these issues over the course of the year, both because of the drought situation and the level of water available in Sacramento, and also because of the litigation that's been pending, was just decided at the Court of Appeal, and the ongoing challenges that counties are having meeting their stormwater needs that have been in discussion for years, but with all of these emerging at the same time, have really coalesced around ongoing dialogue on how to address these issues. So the purpose of the webinar will not be to provide, detailed, in-depth discussion of the last 20 years of Prop 218, or even to provide solutions to these issues, but to give a framework for the discussion that will be going on through the course of the year so that CSAC's members can be educated and engaged as we collectively think about solutions and alternatives to our current structure. So with that, we're going to start with a pretty basic overview of Proposition 218, just to give a framework before I turn it over to Mitch so that he can talk a little bit more specifically about the stormwater issue. And Proposition 218, of course, was adopted by the California voters in 2006. It includes a variety of provisions related to taxes and initiatives, but for purposes of our discussion today, the main focus is on the provisions in Prop 218 that created a new class of property-related fees subject to a number of limitations. So the types of limitations include both procedural limitations, and those are contained in Article 13D, Section 6A and C. That's the requirement for a majority protest and an election for any property-related fees or costs, and significantly, though, the election portion of that requirement is not required for water, sewer, or refuse collection. And another procedural element of Prop 218 that we've learned from case law since it was adopted by the voters is that stormwater is not water or sewer for purposes of that exemption. So while water fees and sewer fees are exempt from the election requirement, stormwater fees and charges are not considered property, or are property-related fees subject to 218, but are not exempt from the election requirement. Proposition 218 also included significant substantive requirements for property-related fees. Those are in Section 13, Article 13D, Section 6B. That section contains a list of 5 distinct requirements. For example, fees can't exceed the total service costs. There's a prohibition against charging for future services. But significantly for our discussion today, particularly on the water rates issue, is the proportionality requirement found in that subdivision. And that says, I'm going to read, just quote it directly, the amount of a fee or charge imposed upon any parcel or person as an incident of property ownership shall not exceed the proportional cost of the service attributable to the parcel. So in a very quick 2-minute overview, those are the parameters that we're dealing with when we're considering stormwater and water rates. And I'm going to turn it over to Mitch now to talk a little bit more about the stormwater element.
Great, thank you, Jennifer. So let's take a step back and look at our overall water portfolio in California. And for administrative reasons, we divide water up into 3 sectors. We have the water sector, the wastewater sector, and the stormwater sector. And the water sector and the wastewater sector are managed generally by utilities, and the stormwater sector provides services primarily by local government. Now the stormwater sector we have divided up into 4 elements, and we've done that because these 4 elements are often operated and managed by different agencies, and they're also regulated differently by regulatory agencies. So first we have groundwater supply, and this is trying to infiltrate stormwater into the watershed. It's to increase retention time of stormwater, so it'll infiltrate in the ground, recharge our groundwater supplies for both human use and environmental use. And then we have flood control infrastructure. This is the purview generally of flood control districts. So these are the like backbone, big major regional facilities that provide flood protection to large areas. And then on the other side, we have drainage infrastructure, which is the pipes that run underneath the streets in your city and town. And those are often maintained by the city or county unincorporated community whichever applies. And then last, we have stormwater quality, and that is your so-called MS4 permit, the NPDES permit that's issued by the Regional Water Quality Control Board, and there's requirements to reduce pollutants in the stormwater. So that's the 4 elements of stormwater. Now I'd like to, actually before I do that, I'd like to kind of give us some, let's call it fun facts on stormwater in the state, and this is kind of a statewide view. So interestingly enough, there's 1 in 5 Californians that live in a floodplain, and $575 billion worth of structures that reside in a floodplain or are located in a floodplain and subject to some risk of flooding. There's also 1.8 million people each year that get sick from polluted stormwater in Los Angeles County, and that translates into $51 million worth of healthcare costs in both Los Angeles and Orange County due to stormwater pollution related issues or illnesses. And then lastly, we all know about the depletion of groundwater and the subsidence of land, primarily in the Central Valley, and up to 28 feet of subsidence near Mendota. So that's some facts on stormwater and why it's important to invest in stormwater. Now I'd like to talk about the kind of a local, more focusing on a local story in Contra Costa County, which is where I'm familiar with. And I'd like to talk about just the history of 2 services. So we were talking earlier about having the stormwater sector and having 4 elements. So I'm just going to talk about 2 of those, flood protection and stormwater quality. So if we look on the left of your screen, we're going to focus on the flood protection services. And in Contra Costa County, we have 79 miles of channels and 29 detention basins. And this system has a value of $1 billion. We actually went out and added up the construction costs of all the facilities, brought it forward to $2010. It all adds up to $1 billion of asset value that's in the ground. And that protects $25 billion worth of structures in Contra Costa County. So it's a good investment. Now it turns out if we have that size of a system, we should be investing $30 million each year as our budget for that size of infrastructure. However, the budget we currently have is about $4 million. So you could look at that as about a $26 million shortfall, or what I like to call as a disinvestment each year. If you add up that disinvestment since the time that we had this difference in what we could charge or develop as revenue sources for maintaining our infrastructure back in Proposition 13 in 1978, if you add up all that disinvestment over the years, it adds up to over $500 million. So that represents kind of the hole that we are in, you might say, in Contra Costa flood protection. Now let's look at the stormwater quality side. These are the permits issued by the Regional Water Quality Control Board to reduce pollutants in our stormwaters. Our current permit, the cost of that is about $37 million per year, and that's with all the cities and the county in Contra Costa County. We have a dedicated revenue in Contra Costa County that generates about $14 million per year, which is fortunate. A lot of counties don't have that. But still, even with that, we have a $23 million shortfall again, and that is currently covered by general funds or road funds or some other type of fund from the cities and counties. Now, we do have a new permit coming out in November 2015. I'm referring now to the San Francisco Bay Area Regional Board up in the Bay Area. And that new permit is going to require what's called green infrastructure plans. These green infrastructure plans has a concept to rebuild the built environment over the next 50 years. So you'll totally reconstruct all paved surfaces so they will treat and infiltrate stormwater in the landscape. So that's going to be extremely expensive. I would note that in Southern California, who's always ahead of us in the Bay Area, they had a permit issued a year or two, a couple years ago. Their permit, this is a new permit, required what is called watershed plans. It's a little different, kind of a similar concept, trying to deal with all the pollutants down in Southern California. The city of San Diego went through and analyzed what the compliance costs were for that permit, and they estimated it at $200 million per year. We looked out over a 20-year horizon. It was $4 billion over the next 20 years. So just as a kind of a look at how we spend money in terms of household expenditures, in Contra Costa County, this is a typical household in Walnut Creek, and this is in our best funded watershed in the county, the Walnut Creek watershed, and the taxes, they're generated about $81 per year per household, and then you'll see the other household expenses annually for this typical household. I would like to say just one more kind of story that's kind of local in Contra Costa, recognizing that we needed additional revenue for our stormwater program, the stormwater clean water program. We went out for a fee in 2012, and in compliance with Proposition 218, we had to send a ballot measure out to all the property owners in the county. There's over 300,000 parcels, notices, and what have you. It took us a year and a half to do this process, this election, and it cost us $1.5 million. The recommended fee was $12 per year per parcel in East County, and about 19 or 22 in Central and in our West County. But the time and effort involved in this is substantial in the cost, which is the point I wanted to make. So now I think maybe Jennifer, you can talk a little bit about water rates. Yeah. The next hot topic today, rather than stormwater.
Great. So just kind of shifting gears then to talk about the other element in Prop 218, which has received a lot of publicity recently, not only because of the San Juan Capistrano case that was issued in April, but also just the drought conditions and the general reduction obligations that local governments are facing in light of the state's actions with the governor's orders and the State Water Resources Control Board orders. So to talk a little bit, and I know there are county councils on the line and others that are very familiar with Prop 218, this will be a very abridged version of some of the major case law development impacting water conservation rates. As I mentioned, Prop 218 was adopted in 1996, and when the omnibus bill was enacted, there was very little in that bill originally that talked about property-related fees, the property-related fees element of Proposition 218. And as a result, much of what we understand about the property-related fees comes only from litigation. If it wasn't clear in the constitutional amendment itself, we got very little guidance from the legislature on these issues. But in terms of water rates, the case I wanted to start on came out in 2006. And after many years of litigation on these issues about what it means to have something be property related, in 2006 the Supreme Court issued its decision in the Bighorn Desert View case, and that's when we learned for the first time definitively that metered rates for consumption of water are property related fees subject to 218. So prior to Bighorn, public agency lawyers had been arguing that the property related fee provisions of 218 didn't apply to fees based on measured consumption of a utility, because whether and how much of a utility a property owner consumes is a voluntary decision. It's not merely a necessary aspect of property ownership. And that had gotten some traction in the courts of appeal, but when the issue was presented to the Supreme Court, they unanimously decided that no, in fact, water rates and utility-based fees measured on consumption are subject to are considered property-related fees, and so they're subject to the 218 and those 5 elements that the fees have to be consistent with that I mentioned before. So fast forward a little bit to another significant development in the law, and in 2011 we had the case called Palmdale versus the Palmdale Water District case, a case out of the Court of Appeal that looked at the constitutional obligation to conserve water. As most people know, Proposition 218 is in the Constitution in Article 13D, but Article 10, Section 2 also contains a requirement that we conserve water as a resource for the use of the people. And so in the Palmdale case, there was an effort to reconcile these two concepts. You have an obligation to conserve water, a constitutional obligation. At the same time, you have constitutional limits on what fees you can charge in order to achieve that conservation. And so it was the first time a very significant case case in trying to harmonize those two. And the court said that they don't conflict, that there's not a conflict between 218 and Article 10, Section 2. You have to read them to harmonize together. And what they said is that the record that you use to impose the fees, that you develop your rate structure, has to support the tiers when you're using tiered water rates to support conservation, and that is tied to the volume of the water that's being used, and that is how you go around supporting your conservation. You don't get to go over and above that by means of Article 10, Section 2. So we've had that case on the books since 2011, and a lot of water agencies and rate setters have been figuring out what exactly that means. There was a lot of question about whether Palmdale was just a records case. In other words, the particular record in that case didn't do a very good job explaining why the water rates were established. In fact, they had a rate study there, and the board, the district board, adopted an ultimate plan that was not consistent with the rate study, and so there were some records issues. And so when the Capistrano case was working its way up through the courts of appeal, we thought it would be a very significant case on this issue, even though Palmdale had already established the notion that the conservation requirements in the Constitution were not going to be significant enough to allow us to impose conservation rates alone, that they had to be tied to proportionality. The issue was really teed up in the San Juan Capistrano case. So a little bit of background on that case, because it is so much in the news and on people's minds, and it's so recent. Certainly I would urge anyone to take a look at the case, because this will just be a rough overview. But in that case, the rates were calculated based on what's known as the M1 manual, which I think is a fairly typical tool for a lot of water agencies to use. And essentially what they did was take the total costs of supplying water in the district, including the debt service on the infrastructure. And they identified the classes of users that they had within the district, so residential, both regular sized parcels and large, construction and agricultural. And then they created their budgets based on 4 levels of water usage. So they had a low, a reasonable, an excessive, and a very excessive. And so that the result is to design the tiers to hit the target number that they needed to hit their overall budget. So it would be a budget neutral tier. So you take all of your costs together, you divide them up among your different types of users, that determines your rate structure, and then those are your rates. They did not, however, calculate the incremental cost of providing the water at each level represented at each of the various tiers. And so the court actually made a specific finding that those at the top of the tiers, so those using water at very excessive rates, would be subsidizing, in essence, those at the bottom that were having very low use rates, because there was no effort to explain why it's more expensive for the agency to provide the water to the high consumers than to the low consumers. They just know that you've got a budget that you have to meet at the end of the day. And the court said that's not going to be accessible. So they were very clear that tiered rates that address conservation in some way are not inherently constitutional. You can have rates that go up or down progressively in relation to usage, but that they said the tiers have to correspond to the actual cost of providing service at that usage level. You can't back into it by allocating costs on price levels based on what your overall agency budget is. You have to have a tier by tier specific study about what it costs to provide water to various levels of usage. And so that's kind of the background of where we ended up in Capistrano. That decision was just issued in April, so I think we're still digesting that and understanding exactly what it means. But it didn't negate all of the rates that are out there, but it made very clear that the standard is going to be extremely high in order to have conservation rates survive Proposition 218 challenges. So talking a little bit about what we know, what we've learned in the past few weeks having read Capistrano, and here I would issue the typical kind of lawyerly warning that obviously every county will need to consult with their own lawyer on these issues because they're emerging and they're very fact specific. But in general, when you're looking at the Capistrano opinion, I think the most important thing to keep in mind is it's the record. And I know I've had conversations with some of my counterparts, county council, that sort of analogize this to the beginning of CEQA. So when CEQA was first adopted in California, the CEQA studies, EIRs and so forth, were fairly small documents. They would have analysis of the project, maybe a few pages, maybe a little more. And you look at CEQA studies today, there are boxes and boxes of material because the CEQA study now is designed to address all of the issues that have come up in litigation over the intervening years and designed to be proactively defending against those kinds of cases. And so I think if you go back and look at some of the rate studies that a lot of agencies have used on tiered rates, you'll probably find that they're maybe not as detailed as the San Juan Capistrano court would require them to be. And so, I would anticipate that if Capistrano remains good law and there are no subsequent changes, your rate studies will start to look a lot more like your EIRs do now, because they're going to have to be so detailed and so specific to address all of the needs to try to justify it under any 218 challenges you might get. So again, records have to be clear and compelling. They have to have support for each tier rate, and they can't be based on budgets, but have to be based on actual usage costs. So the other interesting part about the Capistrano decision that I think we're all struggling with is understanding the constitutional duty to conserve, because we know in Palmdale case that came out in 2011, the court there said you can harmonize the duty to conserve under Article 10 with Proposition 218. And here in the Capistrano case, the court also says that they don't conflict. They don't inherently conflict because the duty to conserve doesn't require above cost rates. There are other things that you can do to address it and still meet the proportionality requirements of Proposition 218. But there's a very interesting paragraph in the decision where the court says, literally says, if push came to shove, that's a quote from the decision, and they were forced to determine that the constitutional duty to conserve is irreconcilable with the proportionality requirements of Proposition 218. They say we might have to read Prop 218 to have carved out an exception to Article 10, Section 2, since Prop 218 is both more recent and more specific. So it's too soon to know what that means for us. They're not negating the obligation to conserve under Article 10, Section 2. They still say that it can be reconciled, but it definitely calls into question how that reconciliation occurs. And if it is determined later that there's a conflict, there's this notion then the court would say Prop 218 supersedes, and the obligation to fund these programs proportionally is more recent and more specific, and therefore is the duty that's imposed over the Article 10, Section 2 duty. So that's another issue to keep in mind going forward, and one that I think we'll see more case law on in the future. And I guess the last lesson that I would highlight today from the Capistrano case is the notion of penalty rates. And so one of the arguments that the attorneys made in the Capistrano case for the water agency was that, well, these rates are, if you're not going to find that they were justified by our rate study, then you should find that they're permissible, because what we're really doing is charging a penalty for those users who have either excessive or very excessive water rates, and part of our duty is to conserve, and so we should be able to impose penalties on that. And the court just in one paragraph flat out dismissed that notion. They said you can't justify rates that don't meet proportionality merely by calling them a penalty, that it would create a huge loophole in the law for an agency to adopt a set of rates and at the same time adopt an ordinance establishing a penalty and call the penalty something other than a rate in violation of Prop 218. So not a lot of analysis on what that means, but clearly there's a notion that just calling something a penalty rate, especially in a post hoc way following a 218 challenge, is not going to survive constitutional muster. So that's kind of where we are in the law on water rates. That's about a 10-minute overview. And again, it's a very complicated issue, but the idea is to provide a framework so that everyone is informed on this discussion going forward. And I think that segues nicely into what the discussion will look like in the coming year on these issues. And I might turn it back over to Mitch to talk a little bit about 218 and changes in that arena.
Thank you, Jennifer. What's a stormwater agency to do, and a water agency, with all these new requirements? On top of that, we have climate change, which is making our environment more volatile, less resilient, and we've got different management requirements today than when Proposition 218 was drafted back in 1996. And just from an outsider looking in, and not being an attorney, it seems like Proposition 218 was granted exemptions to the election requirement for essential services or basic services like water, sewer, and refuse collection. Stormwater at the time wasn't a big issue as it is today, and we have a drought today, and we've had flooding since then, and we have different requirements and needs today than we had then. And I think one question is stormwater now considered a basic or essential service, that if Proposition 218 was drafted today, would stormwater be included because of the different view of stormwater as a resource and something that should be considered a viable or rather an essential service, so that we can fully fund our total California water portfolio of those three sectors, and all three sectors are adequately funded, at least have the same processes. So maybe that leads us into some of the options that we have in dealing with these challenges, and certainly making changes to Proposition 218 is one of those options. And in fact, CSAC has, as one of their kind of legislative platform policies, is to look at or consider changes to Proposition 218 that would allow local governments to manage water more responsibly and kind of react to a lot of these issues that are coming at local governments, such as regulatory requirements and mandatory reduction in usage and that sort of thing. So we have to be more nimble today than we were in the past, and have the ability to have some funding for that. So Jennifer, you want to talk about maybe the police powers and that sort of thing?
Yeah, well, so moving on to some, and the changes to Prop 218, I know Mitch talked about them in the context of stormwater. Certainly that's been under a lot of debate and consideration about expanding the exemption, since the court has told us that stormwater is not water or sewer, and so it has to go out for election. Similar changes could be made on the rates, water rate structure side for conservation, because now the courts have told us that there is no ability to impose a rate that's based purely to encourage conservation. It can only be tied to proportionality of use by the parcel. So, you know, if you're looking at Prop 218, I think that can be an element of it too, and I'm sure will be part of the dialogue going forward for those that are taking this seriously this year. And that's a process, obviously, that there are two ways to get it on the ballot. You go through the legislature, would require a 2/3 vote of the legislature to place that issue on the ballot, or you would go through the signature gathering process. So just in terms of the political realities of that, I know all of that will be discussed in the coming year. Many of you may be involved in those discussions, and a lot of things on the table, especially given our funding crisis and our drought crisis here in California this year. But looking at the Capistrano case in particular, and trying to think of what agencies can do to work around that and to address the rate issue and the conservation issue. I mean, clearly, agencies are going to be taking a look at their rate plan studies for their water conservation rates, either revisiting existing studies if they're facing challenges, or any agency that is anticipating an increase in their rates and going about the new plan. I think those rate studies will start to be extremely detailed and specific, and taking into mind what the Capistrano court said is the new requirement. So, you know, as I said, the court did not invalidate tiered rates. I know there was a lot of hyperbole on this case. It's not a great case for local agencies on this issue, obviously, but there is still a way to do tiered rates as long as your rate plan study is very specific about the costs at the various rates. So an option that requires a lot more review. And the other issue, another potential option, is looking at something outside of the rate setting structure. So we know from the Capistrano case that they're not going to allow a water agency, for example, a water district, to adopt a rate and call part of it a penalty. There was very little analysis there. The court never examined, for example, a local agency, a local government like a county that has inherent police powers to do something like declare a drought emergency and impose restrictions on water use and penalties for those use that really are not related at all to the rate structures that the water agencies are being involved in. Now, clearly this is an emerging legal issue, but I think it's one that warrants additional conversation within cities and counties to see what existing authority might be there for those agencies that have police powers granted to them in the Constitution to address things for the public good. And so that's another consideration. And lastly, I'm sure there will be discussions on legislative options. You can't amend the Constitution by legislation, clearly, and any legislation that does get adopted needs to further the voters' intent as to the legislation. But I've heard proposals discussed, and I think there'll be a lot more discussion in the coming year of what we might be able to do legislatively, particularly on the water rate side. It's probably a lot more difficult on the stormwater side, but on water rates, for example, could you redefine what a property related fee is? And you could say the fee related to property is only what's essential, right, to use that fee. And if you're going to go in excess of that, that's not really related to your property. That excess use is something far beyond that wouldn't be subject to Prop 218. Obviously requires significant legal analysis, but I feel certain that people will be trying to look for these alternatives of explaining better what the voters must have had in mind in 218 without, putting a stranglehold on the ability of cities and counties and water agencies to provide service, to protect their citizens, and to conserve water as is required under the Constitution. So emerging issues, clearly up for discussion, no hard solutions here, but a lot of things to think about, and I think we hope that you all be engaged in that discussion going forward.
If you have any questions, you could contact either Jennifer or myself with the contact information on the screen before you, and there's also a website out of the Contra Costa County website, webpage, that has additional information on stormwater in particular issue. And we're ready to take any questions that you may have out there.
We have a question, I think, for Jennifer. There was the Palmdale case, and then the Capistrano case came down and clarified that further. Are there other cases working their way through the courts that might have further effects on this issue?
So I guess the first thing I would say about that is that the Capistrano decision isn't final yet. I know that the city had initially petitioned for rehearing in the Court of Appeal and has since withdrawn its petition, but there is still an opportunity for interested parties to seek depublication of that decision. And I think it takes 60 days from the time the decision is issued before it becomes final. So there's kind of I think, you assume that it's final and you move forward. There still are some procedural hurdles that the opinion has to complete before it would be considered final. I'm also aware of other rate challenges under 218 for tiered rates that are pending in the courts of appeal. Some, I'm told, have better factual situations than others, maybe even with stronger records than we saw here in Capistrano. I'm been told that those are at least 2 years. I'm sorry, I said they were in the Court of Appeal. I understand that they're working their way through litigation process and will probably ultimately be appealed to the Court of Appeal. So, 2 years, maybe we would see other cases on this issue come up. And so it gets into the sort of the technical aspect of what Capistrano does. Capistrano is binding on all trial courts the way that our legal system works, but a court of appeal could take up the case and disagree with a fellow court of appeal. So we could see a different ruling, a conflicting ruling on a different record come up and then potentially get elevated to the Supreme Court. All of this obviously is on a very long time frame, and it involves a lot of conjecture. So I think I'll move forward at this point, reading Capistrano and trying to interpret it and think about options, but I don't know that it's the end of the story in the courts.
One other question, I think for Mitch. One of the things that's made funding stormwater and flood control difficult is the regulations from the state and the federal government. Are there more of those in the works that we see coming that will exacerbate this issue?
Thank you, Jeff. I think it's fair to say that more regulation translates into more need for funding as costs go up with each regulatory requirement. And the lessons and experience from the past is that looking at, for example, the clean water permits from the regional boards, they are issued on a 5-year interval, and with each new permit that's reissued, the cost of complying with those permits goes up. So every 5 years, you can look at an increased cost for your clean water program in your municipality. Permitting costs go up for projects. Now, flood control projects or any other kind of infrastructure project, the environmental permitting costs are continue to go up, mitigation costs. So yes, all the costs are over time, in our experience, has increased because of the, and not just because, but with the regulatory changes.
Well, we don't see any other questions, so we'd like to thank our presenters, Mitch and Jennifer. We'd like to thank the audience for tuning in today. Be on the lookout for our next webinar, which will be in June. You can hear about that from our website at www.counties.org or from our weekly bulletin sent out on Fridays, the CSAC bulletin, or follow us on Twitter at CSAC_counties. Thank you.